and First Amendment rights. In November, several attorneys and law students discussed the Supreme Court case, Jerry Falwell versus Hustler magazine. The discussion was part of a day-long conference at the University of Virginia Law School. It's an hour and 10 minutes.
Good morning. I'm Bob O'Neill, the director of the Thomas Jefferson Center, and I have the honor and pleasure of welcoming all of you to what is the third in our series of Virginia Cases conferences. For most of you, I suspect this may be your first such event. In the 2 previous years, we took a close look 2 years ago at the origins through Virginia cases of the doctrine of commercial speech, and last year in the Richmond newspaper's case at access of the media and the public to the criminal courtroom. For reasons not entirely clear to us, this year's conference has attracted considerably more attention than did either commercial speech or access to the criminal courtroom. This is a different, a historic, a very exciting event. One suspects that Thomas Jefferson would be pleased if he were to look down, well, in fact, we know he does look down always upon what's done at his university and at the center which bears his name. We're not entirely sure which way he would have decided this case had he been on the court to which it was assigned, but we do know that he would have seen this as a very difficult contest of issues, a case that really called forth the best from those who argued it and those who commented on and wrote about it. To give us perspective in our first session on everything from the views of Mr. Jefferson to the advent of this very case, we're especially fortunate to have as our speaker the person who literally wrote the book about it. Professor Rodney Smola, as I'm sure most of you know, is the Arthur B. Hanson Professor of Law at the College of William and Mary, where for some years he directed with great distinction the Bill of Rights Institute. He guided the programs of the Washington Annenberg Center through the closing of that center relocation last year. His book, Free Speech in an Open Society, which is truly a Bible for those of us who share his commitment to this field, received the William O. Douglas Prize. An earlier work, Suing the Press, Libel, the Media, and Power, earned for Professor Smola the ABA Gavel Award Certificate of Merit when it appeared about a decade ago. I'm happy to say that what Professor Smola preaches or writes about, he also practices. He's been involved in a host of important free speech and free press cases over the years. He does have a special role in our program today. He wrote the book on the case, Jerry Falwell versus Larry Flynt, the First Amendment on Trial, which appeared in 1988 in hardcover and in paperback 2 years later. I assume, by the way, Rod, the sales have been fairly brisk in recent months. Professor Rodney Smola.
Well, thank you very much, Bob, for that very gracious introduction. The case that we are going to examine today is not a pretty sight, and so a viewer discretion is advised. This is a rare thing for C-SPAN. You might actually have to tell the kids not to watch it. It is truly and only in America's story. It's not just a lawsuit, it's a lesson. It's a parable. A parable, if you will, about our national identity, about the conflicts in our constitutional unconscious. We have with us today on this program 2 truly extraordinary Americans. Let us first consider Reverend Jerry Falwell, a great man dedicated to a great mission, a man of profound and abiding faith. Reverend Falwell believes that truth exists. He believes that truth is knowable. Most importantly, he believes in right and wrong. He is not, I think, contrary to the caricature that is often made of him, a self-righteous and intolerant and close-minded man. He has a deep sense of ecumenical tolerance. He has always shown a special affection and solicitude for the Jewish people and for the security of Israel. He has intellectual disagreements, but cordial and civil relations with ideological foils like Senator Ted Kennedy. And he is known in his professional and personal affairs to be a person of humor and easy manner. But make no mistake, Reverend Falwell stands for something. He may not be self-righteous, but he is a believer in righteousness, and certainly a believer in the elemental concept that there is such a thing as a right. And right, for Reverend Falwell, means the rejection of secular humanism, the rejection of moral relativism, a rejection of promiscuity, a rejection of abortion, a rejection of the exploitation of women, and of the crass and cheap purveying of sex through the mass production of pornography. Now, many people believe the things that Reverend Falwell believes, but he occupies a place in the American panoply that is unique. Why is that? What distinguishes Reverend Falwell in our collective consciousness from the thousands and thousands of other reverends, great and small? It is, I think, that Reverend Falwell believes, as much as the foundations of his own fundamentalism, that it is his right and it is his duty to enter the civic and political arena with his religious and moral message. Now, virtually all Americans believe in separation of church and state, but we disagree about what it means. Reverend Falwell crystallizes in our minds the idea that separation of church and state does not mean that the church is to stand by idly, mute and indifferent to the perceived moral outrages of the day. We are put on earth to do God's work. And how are we to do God's work but through the practical affairs of men and women? How are we to do it but by attempting to influence the law? It was Oliver Wendell Holmes, after all, who said the law is the witness and external deposit of our moral life. Contrary to the old view, you can't legislate morality. In this view, you must legislate morality. Indeed, you cannot help but legislate morality, because that is what all law does. And so for someone like Reverend Falwell, there is nothing wrong with a preacher using the pulpit, using the means of mass communication, using his charisma and his organizational skills and his powerful proselytizing voice to push the government to do the right thing, to pass laws that will elevate the culture, make us better people, promote community values, stem the moral slide. Which brings us to pornography. For pornography, in Reverend Falwell's view, is truly a terrible thing. It is contrary to God's will. It eats at the moral fabric. It degrades women. It cheapens sex. It corrodes the integrity of relationships and the binds of family. It ought to be fought. It ought to be fought from the pulpit. It ought to be fought in the legislative halls. Now, are you starting to see what we have here? This is not just a lawsuit. This is not just a fascinating conundrum in the law of torts or the intricacies of First Amendment theory. This is a battle over competing visions of America and the notion of the role and the rule of law. So let us meet the other combatant, Larry Flynt, another extraordinary American. My, Larry Flynt. Larry Flynt, where do we start with this story? He is, on one level, the quintessential American entrepreneur. He took a string of strip joints in Ohio and parlayed them into a multi-million-dollar empire driven by Hustler magazine, which carved its own unique niche in the porno market by combining the slick paper appearance of Playboy or Penthouse with no-holds-barred raunchiness. Whereas Playboy and Penthouse cultivated an air of chic sophistication, Hustler displayed no pretense of pretense. It was the magazine nobody quotes. The magazine for which no topic was too revolting, no image too repulsive. The magazine where you could find excrement and mutilation and bestiality and dismemberment and bondage. But if Hustler magazine was at times at least seemingly a bit out of control, it was nothing compared to Larry Flynt, who, to say the least, has lived life on the edge. In 1977, for example, he underwent a religious conversion experience, befriending, in a very deep personal relationship, the evangelist Ruth Carter Stapleton, the sister of President Jimmy Carter. And for a period, Hustler magazine was indeed a sort of surreal montage of porn and Christianity. For my taste, a kind of screwball mixture of sex and religion. Porn again and born again. A grab bag of crucifixes and sexual aids. As you know, tragically, Mr. Flynt was shot in the abdomen and very seriously injured in Lawrenceville, Georgia in 1978 while standing trial for obscenity. He was in years of pain as a result of that. Some of that affected some of the events of the case that we're going to study. And even today, of course, is confined to a wheelchair. In other extraordinary episodes in his life, he obtained copies of the FBI tapes of a sting of John DeLorean, who was accused of conspiring to import $24 million worth of cocaine. He ran for president with the famous Native American activist Russell Means as his running mate. And of course, above all, Larry Flynt and Hustler magazine constantly stuck it to the man. They constantly attacked the powerful people in the United States, particularly public figures and public officials that in Mr. Flynt's view represented forces of repression. And so people like Chief Justice Warren Burger or President Ronald Reagan or, yes, Reverend Jerry Falwell were frequent attacks of Hustler and Larry Flynt. Now, the particular attack on Reverend Falwell that gave rise to this fascinating lawsuit was an advertising parody run by Hustler in 1983. Now, those of you in the live audience have a copy of it. Those of you watching on television are barred by FCC rules from seeing this. It is, on its face, a mock Campari liqueur ad. Now, many of you have probably tasted Campari liqueur. It is, as the euphemism goes, an acquired taste. And one of the problems you have when you manufacture a liqueur or any product that is an acquired taste is how do you get people to acquire it? And so in a very, very clever advertising campaign that ran for years in mainstream upscale magazines like Esquire or Vanity Fair, the Madison Avenue Company that represented Campari liqueur would run a series of interviews with the glitterati, with Jill St. John or Elizabeth Ashley or Tony Roberts, and these people would have their picture in the corner and they would muse philosophically about their first time. And of course, the clever, racy, sexy double entendre was that although on the face of things it was the first time they tried Campari, really it was the first time they'd had sex. And it usually turned out that it wasn't that great the first time. But the subliminal message was that Campari, like sex, gets better with practice. Well, Hustler thought it would be funny to run a humorous ad with an edge to it in which Reverend Jerry Falwell talked about his first time. Now, can we just talk audience to speaker for a minute? I have a problem at this moment in my talk because I don't know what's the appropriate thing to do, Bob. I don't know whether I should read the ad to all of you now, or whether I should just say the ad is in your materials and to save time we will skip over it. It's a serious problem because on the one hand, arguably reading the ad would be right now, today, to yet again insult Reverend Falwell. On the other hand, not to read the ad is to sort of give credence, arguably, as we debate this case, to the view that the ad's inappropriate for public discourse. I'll tell you what I've decided to do. Like a good lawyer, I'm going to compromise. I'm going to read pieces of the ad. And the theory for me is the case is long over. It's passed into history. It's part of the official record. And it's fairer to both Flint and Falwell to read it. Fairer to Flint because it tells us that we have some respect for the freedom he believes he had to publish it. And fairer, I actually think, to Reverend Falwell, for it places in evidence in front of us all the object of his outrage. So you can turn and read along if you like. Page 1 of the hymn book, Jerry Falwell talks about his first time. My first time was in an outhouse outside Lynchburg, Virginia. Wasn't it a little cramped? Not after I kicked the goat out. I see you must tell us all about it. I never really expected to make it with Mom, but then after she showed all the other guys in town a good time, I figured, what the hell? But your mom, isn't that a bit odd? I don't think so. Looks don't mean that much to me in a woman. And then the ad goes on and describes in vulgar and graphic terms Jerry Falwell talking about his first time in an outhouse with his own mother. Well, Reverend Falwell took this to be offensive, and he photocopied hundreds of thousands of copies of this ad and sent it out in mass mailings within weeks of seeing it to donors from his various donor lists, including the lists generated by his popular television show, The Old Time Gospel Hour. And through these prodigious efforts, he quickly raised, in a matter of weeks, over $700,000 as a litigation war chest to file a lawsuit against Hustler and Larry Flint. By the way, in an interesting aside, which we'll hear more of today, Hustler, in turn, sued Reverend Falwell in California for copyright infringement. The court held it was a fair use. Jerry Falwell then retained one of the more colorful lawyers of the time, now deceased, Norman Roy Grutman, which for me always seemed a peculiar pick, because up to this point, he had been the lifelong lawyer for Bob Guccione and Penthouse magazine. Indeed, he'd previously been Falwell's adversary, defeating Jerry Falwell in a lawsuit Falwell brought against Penthouse for running an interview that Jerry Falwell had given with a freelance writer. So as an outsider to the case, I thought it ironic. Here was Reverend Jerry Falwell pleading and getting hundreds of thousands of checks, $10, $25, $100 from the faithful, and these are going to Penthouse's lawyer. It was a kind of Baptist to Penthouse Iran-Contra diversion. We'll learn, I guess, from the actual actors in this extraordinary drama, more of that. Perhaps Reverend Falwell knew that Mr. Grutman had a long history of adversarial relations and litigation with Larry Flynt. Perhaps he thought of Mr. Grutman as himself a bit of a devil. And if you're going to sue the devil, maybe it helps to have a bit of a devil yourself as a lawyer. Well, in any event, we then get into the trial. And it was an extraordinary trial by all accounts, and you'll hear from the first-hand participants. One of the earlier events, an astonishing event, involved a deposition in pretrial discovery taken of Larry Flynt. And indeed, as I make that statement, I saw Mr. Flynt crack into a huge grin as he remembers what was at the time, I'm sure, not a particularly pleasant experience. He was in prison at the time, doing time, and he was in a pathetic condition. In pain, paralyzed, unkempt, bearded, ridden with bed sores, and handcuffed to a hospital gurney. The deposition wound on for hours and hours. Let me simply read you a few excerpts from it. Start off with simply the very opening of the deposition. Can you raise your right hand? No, they're cuffed. Do you solemnly swear that the testimony you are about to give is the truth, the whole truth, and nothing but the truth, so help you God? No, not till you take the cuffs off. Deposition goes around and around and around, and then we get to this moment. Mr. Flynt, the oath has been administered to you. You don't have to call me Mr. I came up through the ranks, Mr. Grutman. Mr. Flynt, the oath has been administered to you. You heard the oath. Do you swear to tell the truth and nothing but the truth, so help you God? No. You do not? All right, will you tell me, sir, please, whether you will affirm to tell the truth, the whole truth, and nothing but the truth? No. I will never affirm to tell the truth as long as these handcuffs are on, Mr. Grutman. And they go around and around and around and around. Finally, Mr. Grutman says, I take it you have no religious objection to taking my oath. Is that correct? I'll swear to anything, Mr. Grutman. To get these cuffs off, I'll declare you God. But I ain't talking to you with them on. Now, you can stand there and talk till the cows come home, but I ain't answering no questions till the cuffs come off. Apparently, at this point, Mr. Grutman got exasperated. There are negotiations, and eventually the cuffs come off. We try again. Mr. Flynt, what is your full name? Answer. Christopher Columbus Cornwallis, IPQ, Harvey H. Apache Pew. I like that. Christopher Columbus, IPQ, Harvey H. Apache Pew. They call me Larry Flynt. And all those historical figures. Are you known as Larry Flynt? Well, no, Jesus H. Flynt, Esquire. Have you ever called yourself Larry Flynt? Used to, but it was spelled with an I then, F-L-I-N-T. Now it's F-L-Y-N-T. I have 2 birth certificates. Were you born in Kentucky? No. Have you served in the United States Navy? I'm not sure. Have you ever lived in Dayton, Ohio? No. I was hatched in Dayton, Ohio. And the deposition goes on. At various points, Mr. Flint gets radio signals from helicopters, and officers are down, and there is a sort of crazy, rambling set of stories about his life and conspiracies and American public figures and the proof that he has that, yes, indeed, Jerry Falwell did sleep with his mother in an outhouse. We then come down, and you have to remember, this is hours and hours and hours. We then come down to one other moment that is enormously important for us to consider as we set the stage for this case. This is the moment in which Flint is being grilled on why he did this. Let me pick up the Q and A. Do you realize that in having published what you did in this ad, you were attempting to convey to the people who read it that Reverend Falwell was just as you characterized him, a liar? He's a glutton. How about a liar? Yeah, a liar too. How about a hypocrite? Yeah. That's what you wanted to convey. Yeah. And didn't it occur to you that if it wasn't true, you were attacking a man in his profession? Yes. Did you appreciate at the time you wrote okay and approved this publication that for Reverend Falwell to function in his livelihood and in his commitment and career, he has to have an integrity that people believe in? Did you not appreciate that? Yeah. And wasn't one of your objectives to destroy that integrity or harm it if you could? Answer: to assassinate it. Good person to have as your client, by the way. Now, we come to the trial. In the trial, things are a bit different. Fortunately for Mr. Flint, he has recovered from a lot of his afflictions. He is in much better shape physically, psychologically. He presents himself at the trial as clean-shaven, as calm. He portrays a sort of a country boy who made it quality. And he is, by all accounts, quite charming. The jury, however, is shown not only the live Mr. Flint in front of them, but the deposition. So they see the two sides of Larry Flint, at least in the eyes of the plaintiff. If there are just two sides, sometimes I think there may be a few more. Jerry Falwell also takes the stand, and his testimony is long and interesting, and we, of course, don't have the luxury of going through it in great depth. But there is one important passage in which he is describing the effect of this ad on him. Now, none of us can get inside Reverend Falwell's mind or inside his heart. None of us can get inside the heart or mind of another. But all of us as human beings must have an element of curiosity. Did this really hurt you? Did this really kill you? Or are you such a tough person out there in the arena all the time that you had a different agenda? You just wanted to punish Hustler and punish Larry Flint, and you never really felt any deep distress. I think it's important for us to consider the crucial piece of testimony from Reverend Falwell on this issue. He's being asked about the effect the first time he saw the ad. Here's his answer. I think I have never been as angry as I was at that moment. My first impression was that Campari had purchased an ad in the magazine because I had seen a similar ad in a decent magazine years earlier, and my first thought was to get on the phone to Campari. Our in-house attorney and I talked it over. My anger became a more rational and deep hurt. I somehow felt that in all of my life I had never believed that human beings could do something like this. I really felt like weeping. I'm not a deeply emotional person. I don't show it. but I felt like weeping. How long did this sense of anger last? To this present moment. A bit later in the same colloquy, you say that it almost brought you to tears. In your whole life, Mr. Falwell, had you ever had a personal experience of such intensity that could compare with the feeling that you had when you saw this ad? Now think about that question. This is being asked to Reverend Jerry Falwell. Did you ever have a more intense experience? You might think he would now talk in religious or mystical terms, but no. Here's his answer. Never had. Since I had been a Christian, I don't think I have ever intentionally hurt anybody. I'm sure I've hurt people, but not with intent. I certainly have never physically attacked anyone in my life. I think that at that moment, if Larry Flint had been nearby, I might have physically reacted. Well, we're almost set to hear a reenactment of this magnificent case as it happened in the U.S. Supreme Court. Let me just take in closing a few more minutes to invite you for a second at least to think like lawyers, whether you are one or mercifully perhaps are not. Reverend Falwell actually sued under 3 different legal theories. He sued, first of all, under the most obvious theory, libel. I'll let you in on a little secret. He never has had sex with his mother in an outhouse. Of course, the ad is a lie. It is on its face libelous. It's false. And so that seems like an obvious nominee. In fact, it seems like a winner. He secondly sued for the appropriation of his name and likeness. There is a picture of him and his name here. And, you know, you can't put Michael Jordan on a Nike ad without paying Michael big time. The theory is you can't place Reverend Falwell in a position like this without paying him. And thirdly, he sued for infliction of emotional distress. Now, he lost on the first 2 theories, and here's why. The judge ruled that he couldn't sue for appropriation of his name or likeness because in Virginia, that is only something we allow you to recover for when the taking is for commercial purposes. So if Falwell's picture had actually been taken to sell Campari liqueur, yeah, he'd have a lawsuit, I guess, against Campari. But it wasn't taken for that purpose. It was taken to entertain. It was taken to engage in a political attack, and that's different. Now, those of you who are thinking fast will say, well, it was also taken for the commercial purpose of selling Hustler magazines. And that's true, but for the most part in this country, that doesn't count as a commercial purpose because that would make it virtually impossible for any news organization to put photographs of people with live news events. Indeed, that doctrine is what, for the most part, allows the paparazzi to stay in business and profit from their photos. Interestingly, though, the court also finds that the jury must be instructed that there can also only be recovery for libel if people really believe that this ad was to be taken seriously, that it was an actual, factual allegation about Falwell, as opposed to a joke, a parody, something nobody really believed was being actually asserted. The judge said that's a jury question. Let the jury read the ad, hear the arguments. The jury will decide whether any reasonable person would really think that Hustler meant it. And the jury said, nah, we don't believe any reasonable person reading this really thought that Hustler was really saying seriously that Falwell had done this. And so the libel count is out. And that leaves us with intentional infliction of emotional distress. Now, in Virginia, to win under intentional infliction of emotional distress, you had to show 4 things. You had to then, you do now, that the conduct was intentional or reckless. Well, I would say this was. That it offends generally accepted standards of decency or morality. Plausible. That it's connected to the emotional distress of the plaintiff. We heard the testimony. That the distress was severe. We heard the testimony. And so the jury returns a $200,000 verdict, half of it in compensatory damages and half of it in punitive damages. And I will tell you, in my view, the jury was right. Given those instructions, it all seems to be there, all the ingredients. The question is, will the First Amendment allow this? The case is appealed to the United States Court of Appeals for the Fourth Circuit in Richmond, and a divided court says it's permissible and affirms the verdict over a spirited dissent from Judge J. Harvey Wilkinson. The United States Supreme Court then grants review. There is a spirited participation by many news organizations, editorial cartoonists, people in the business of satire and parody who write many friend of the court briefs, and the stage is set for the argument that you are about to hear. Now, I'm not going to go over the legal issues in the argument because we have people throughout the day that will do that much better than I can. But I'm simply going in the last minute here to give you some listening tips, a little color commentary here, what to listen for, some of the themes and arguments that you will certainly hear debated among the various contestants here today. First, most broadly, I guess we will here put in issue this question: what is the purpose of the First Amendment? Remember, it just isn't fair to think about this case as pitting Larry Flynt, who believes in freedom of speech, against Jerry Falwell, who does not. That's not fair, because Jerry Falwell believes in freedom of speech and the First Amendment. Both of these men live their lives because of the First Amendment. The question is, what does freedom of speech mean? Does it protect only rational public discourse, or does it also protect the coarse and the irrational? Does it protect only the intellectual content of speech, or does it also protect the emotive content of speech? Should the rule be, say whatever you want, this is a free country, but say it nicely? Or should the rule be, say whatever you want, any way you want? Second little tip to listen for. You'll hear a case talked about. New York Times versus Sullivan, a famous case decided in 1964. A libel case. In this case, the U.S. Supreme Court held that public officials, and later it would hold public figures like Reverend Falwell, can only sue for libel if they can demonstrate that the material was published with knowledge that it was false or with reckless disregard for truth or falsity. Now the puzzle, the fascinating puzzle in this case is, we don't have something published with knowledge or reckless disregard for truth or falsity, because the truth or falsity of this thing is not an issue anymore. We're only focusing on the emotional distress. And so the question is, how do you take New York Times v. Sullivan and its standard and translate it into this different context? Thirdly, listen for the problem of emotional distress, and listen for the problem of the offense that this ad arguably poses to community standards of decency. How will our First Amendment tradition be squared with the idea that we are permitting recovery for the mere infliction of emotional distress? Not bodily harm, not harm to reputation, but just the hurt feelings. And finally, I will stop with this thought. Think about the debate you will hear and what it tells us about the Faustian bargain of celebrity and power in modern times. The Princess Diana debate. What is the price of fame and celebrity? What is exacted from you for entering the public arena? Is it something so extraordinary that it encompasses even an ad that says, although satirically, that you had sex with your mother? I want you to now collectively send your good vibrations, your psychic goodwill, your religious sentiments, whatever you think appropriate, to the two brave students from the College of William and Mary and the University of Virginia who will now replicate this argument. I'm very proud of them both. I hope you will be. I want you to sit back and enjoy the day. Thanks.
I think you now appreciate why we were so anxious to have Rod Smola as our keynote lead-off speaker. He not only has a superb understanding of the legal issues and a complete command of the facts, he has never met a soundbite he didn't like and happily shared many of them with us this morning. The person to whom I now turn over the podium may not be as well known as our protagonists, but is clearly the most important person in the gathering and arranging of this conference. My associate Josh Wheeler, who is the Center's Director of Programs and Development, last summer when we contemplated this prospect, I said, wouldn't it be great if we could get the attorneys who actually argued the case? Yes, he said, I think we may even be able to do better than that. I think we may even be able to get the principal parties themselves. I disparaged that notion. I thought that was an impossible dream, a vision that would never come to pass, but lo and behold, through Josh Wheeler's extraordinary efforts, day to day, hour to hour from that time to this morning, it has come to pass, and I'm now delighted to turn the program over to Josh, who will present our next segment.
Thank you very much. It wouldn't be inappropriate to subtitle today's program The Rod Smola Show. As you can see from the schedule, we have exploited Professor Smola's generosity to the fullest extent possible, asking him to participate in not one but 3 different sessions. After hearing his excellent presentation, I'm sure you all understand why we are working Rod so hard today. Thank you, Rod, very much. Bob introduced you. I'd like to just say a couple of words about the Center before our next session. The Center is a non-profit, non-partisan institution engaged in research, education, and intervention on behalf of the individual right of free expression. Now, all of you have been given a brochure on the Thomas Jefferson Center, and I don't want to take up time now talking about what you can read in the brochure, except to say that the Center is a nonprofit organization, and any of you who've worked with nonprofits knows what that means. We could not do this program, or indeed any program, without the generous support of individuals, foundations, and corporations. And I would like to just take a moment to thank the corporations and foundations that have made today possible. They are Media General, Richmond Newspapers, Virginia Newspapers, and the Virginia Foundation for the Humanities and Public Policy. I'd also like to thank all the participants who are here for no other reason but to share their views on this very important case. Now, let's turn to the next session of the conference, a restaging of the oral argument before the U.S. Supreme Court in the case of Jerry Falwell versus Hustler Magazine and Larry Flynt. I now ask Justices Deichmann, Marino, Isaacman, and Carson to take the bench. The clerk will now call court to order.
Oyez, oyez. The Supreme Court of the United States is now in session. The Honorable Alan Isaacman presiding.
We will hear argument first this morning in number 86-1278, Hustler Magazine and Larry C. Flynt versus Jerry Falwell. Ms. Evans, you may proceed whenever you are ready.
Chief Justice Isaacman, and may it please the court, I am Elizabeth Evans, and I represent the petitioners, Hustler Magazine and Larry C. Flynt. For 2 reasons, petitioners asked the court to reverse the decision of the Second Circuit Court of Appeals that the First Amendment does not protect petitioners' printing of an advertisement parody featuring an entirely fictitious, non-fact-based scenario involving respondent. First, the First Amendment protects satirical and critical commentary of public figures, even when such commentary is made without basis in fact. Second, it is impermissible for a public figure to disguise a claim for libel as a claim for intentional infliction of emotional distress. Broadly speaking, the First Amendment protects political speech above all other. This court specifically held in New York Times v. Sullivan that the court and the country is committed to a wide-open, robust, and uninhibited political debate. The court further found that such a debate may lead to attacks on public figures. In publishing its parody, Hustler magazine has done nothing more than the First Amendment and the court permit it to do.
Ms. Evans, if I can interrupt you for a moment. The Supreme Court has repeatedly said that there is no social value to a deliberate and intentional falsehood. Is there any social value to the deliberate and intentional character assassination that we've seen in this case?
Yes, Your Honor. Hustler magazine's point in publishing this parody was to take aspects of Jerry Falwell's personality and make comment on them. In writing what it did, Hustler questioned the strength of Jerry Falwell's beliefs and their validity. It was inviting debate rather than simply assassinating his character. Had it wished simply to assassinate him, it would have printed perhaps a more realistic scenario, one that the jury could have found it believed, in order to demean him. Because the jury was not able to reasonably believe this scenario, and because no reasonable reader could believe it, the ad parody invited debate rather than simply assassinating Jerry Falwell.
How do you respond to Larry Flint's sworn deposition testimony that his intention in running this parody was not to satirize anybody, but to assassinate Reverend Falwell's character?
Your Honor, first, Larry Flint was in the throes of a manic depressive disorder at the time of his deposition and perhaps was not competent to testify as he did. But second, what Hustler intended to do, again, was to comment upon Jerry Falwell rather than specifically to destroy him and to destroy his reputation. In fact, from its own reprinting of the parody, the moral majority was able to raise $800,000 over 30 days to campaign against Larry Flint. It cannot be said that the parody did not, in fact, invite debate.
Well, Ms. Evans, didn't the jury, wasn't that a question for the jury as to whether his deposition testimony was to be believed or not? When he said it was his intention to assassinate his character, you suggested we should dismiss that. But it appears that the jury implicitly found that he knowingly intended the acts and the injury that he caused. Isn't that right?
Well, Your Honor, the jury dismissed the libel claim. It found that there was no libel. It did find that there was intentional infliction of emotional distress. What is requisite in Virginia for such a finding is simply a finding that the publisher intended to cause Jerry Falwell emotional harm. It didn't have to. The jury did not have to find that in publishing the parody, Hustler magazine intended to destroy Larry Flint.
Ms. Evans, can you draw a line for me between a bona fide parody and just a gratuitous insult? I mean, it seems to me a bona fide parody distorts a fact, a true fact, and characterizes it in some way that is distorted, but is in fact based on some true factual event. Wouldn't you agree with that?
Yes, Your Honor.
Well, then what's the true parody? What's the true fact in this case?
What Hustler excuse me, Your Honor. What Hustler magazine was commenting upon was Jerry Falwell's particular beliefs. What the parody said was Jerry Falwell would never do such a thing as this. He would never have such a rendezvous with his mother in an outhouse. Jerry Falwell would never think about such a thing. He would never drink Campari. He's a teetotaler. The intention was to comment upon the person Jerry Falwell is in order to illustrate the very strength of his beliefs. As an editorial cartoon does, when artists tend to exaggerate features of the subject, the commentary is intended to bring those out and to invite discussion about them.
You may proceed, Ms. Evans.
Thank you, Your Honor. That Hustler chose to publish this parody is legitimate speech because it does take aspects of his personality and his devout Christianity and to comment upon them. Hustler chose to do this using rhetorical hyperbole by exaggerating to the point of stating the very unbelievable in order to make its point. Under Letter Carriers v. Austin and Greenbelt v. Bresler, rhetorical hyperbole such as this is protected speech. Further, under the 10th Circuit case, Pring v. Penthouse, when no reasonable reader can understand speech as true, and that is what the jury specifically found in this case, then that speech cannot be prohibited under the First Amendment. The second reason the court should overturn the holding of the Court of Appeals is that it does violence to the First Amendment to allow a libel plaintiff to restate his claim in terms of the intentional infliction of emotional distress. As Judge Wilkinson below wrote so very eloquently, allowing a plaintiff, especially one who is a public figure, to recover damages based on emotional distress alone threatens the long tradition of satiric commentary in this country. Furthermore, it tends to circumvent the development of the law since New York Times v. Sullivan. Sullivan says that in order for a public figure to recover for libel, the plaintiff must show that the publication was false and that it was made with actual malice. If the court permits recovery for emotional distress alone, as respondents argue it should, then a plaintiff would be able to recover when a publisher prints a perfectly true statement. Allowing recovery of this type would allow plaintiffs to recover using a lower standard and a less objective standard than is required for libel.
Ms. Evans, isn't the real message of New York Times against Sullivan a heightened degree of fault? And if so, how do you apply that to the context of the emotional distress claim?
That's correct, Your Honor. What New York Times established is that in proving libel, a plaintiff must show that there has been actual malice. It must show that the publisher had reckless disregard for the truth. In this case, if there's a requirement that reckless disregard must be shown, it gives a higher standard to the plaintiff. The plaintiff must prove more in order to recover. Under Virginia state tort law, in order to recover, the plaintiff must prove only that there is intent to cause emotional damage. Under that standard, a perfectly true statement can be used to cause emotional damage, and a plaintiff can recover on that basis. However, if the standard is raised to require reckless disregard for the truth, then a plaintiff will not be able to recover unless he proves such reckless disregard. This is consistent with the standard of Sullivan in that it encourages robust, wide-open debate, and it prevents a plaintiff from recovering by using a simple tort claim rather than using a free speech claim.
Wasn't Mr. Flint acting in reckless disregard for the truth when he approved the publication of this so-called compare ad?
Respectfully, Your Honor, there is no truth in this ad, and there is no assertion of truth. As the jury found, nothing in this advertisement could be regarded as true because it contradicts so exactly and so broadly everything that Jerry Falwell stands for.
Ms. Evans, let me ask you, it's clear that we're putting a lot of emphasis here in your argument on the jury finding, and it's, I think, equally obvious that counsel for the defendants and the trial court demonstrated a lot of foresight by framing a specific question asking about whether any reader could reasonably understand the ad parody or the publication to be describing actual facts about Jerry Falwell or actual events in which he participated. Say that that question had not been asked and all that was presented to the jury was a question, do you find for the plaintiff or the defendant? Or say that the jury answered that question in the positive, that is, that a reasonable reader could understand this as describing actual facts. Would we have an obligation now, sitting here, to review that finding, make our own determination?
Your Honor, this would indeed be a very different case had the jury found otherwise. But under the holding of Bose, where a jury makes a determination in favor of a speaker, the court is obligated to protect that speaker at the appellate level. So in this case, the court is not required to make an independent review of the facts found, and the court should, in favor of the speaker, accept the jury's finding.
Excuse me, are you saying that under Bose, the independent review standard applies only if the jury has found against the speaker?
If the jury has, yes, Your Honor, that's correct.
Have we said that?
I don't believe specifically, Your Honor, but it was intimated in Bose that that's correct.
I know you put a lot of emphasis on the jury finding that the statements made in the ad were not to be believed by the reasonable reader. But in satire, I think you start with that kernel of truth and you distort it. So you would not expect an ad recognized to be a parody to be literally believed. But don't you feel that there's a problem in that the jury may have believed that there was a kernel of truth, that perhaps Mr. Falwell was guilty of, Reverend Falwell was guilty of some sexual peccadillo, or in fact was not as abstemious as he states he is?
No, Your Honor, I don't believe that. Reverend Falwell gets up on the political stump every single day to state what he believes in. He speaks out every day against homosexuality, against extramarital sex, and it can't reasonably be found, in light of what he has said 1,200 times a year in his speeches and once a week on the Old Time Gospel Hour, that he would so believe. Any American who's even passingly familiar with Jerry Falwell would understand this. For the reasons that it is constitutionally impermissible for a plaintiff alleging injurious publication to label his claim as emotional distress, and because the First Amendment protects the publication of a parody advertisement that has no basis in fact and that is designed to make political commentary upon this subject, petitioners today ask the court to reverse the decision of the Court of Appeals and to protect their publication. Thank you very much.
Thank you, Ms. Evans. We'll hear now from Mr. Kessa.
Mr. Chief Justice, may it please the court. I'm Rahul Keshup, and I represent Respondent Jerry Falwell. A jury has decided that Reverend Falwell suffered $100,000 of damage as a result of petitioner's intentional infliction of emotional distress, and the petitioner and his business should be punished $100,000 more and as punishment for the viciousness of the attack. The portrayal of Reverend Falwell as committing incest with his mother in an outhouse was so objectionable that the jury sought to compensate him for being the subject of what can only be described as malicious character assassination. Indeed, petitioner admitted to as much in a deposition. It is difficult to imagine a more personal and more outrageous allegation. The question before this court today is whether the First Amendment can trump the finding of a jury which carefully deliberated and reached its considered decision. The First Amendment should not be used as a blunderbuss which indiscriminately rejects any attempt at accountability, but rather should be a scalpel which cuts out efforts to curb speech that is merely unpopular. Indeed, almost all speech will still be protected by affirming the Court of Appeals today. The only exception will be made for cases such as this one, where the intent of the publisher or speaker is to harm the subject by making a claim that is so outrageous and illegal that the average person should not have to bear it.
Mr. Keshup, isn't the concept of outrage, which is an essential element of the tort in Virginia, such a subjective concept that it will be difficult having juries consistently from different parts of the country determine what is legally outrageous and what is legally not outrageous? And isn't that a danger that we create if we allow the jury verdict to stand in this case?
That is a difficulty, Your Honor. Nonetheless, we think that there are important other rights in this case, such as Jerry Falwell's right not to be intentionally inflicted with this distress. And we think that these rights should be balanced off. The First Amendment should not just be a trump card that will work regardless of what was said. We think that in a number of different cases, speech is not protected, and this should be one of those cases where a jury should be made to decide.
Where, Mr. Kessup, would you draw the line between permissible parody and illegal parody?
Well, we agree that the severity of this case is beyond question. Wherever the line must be drawn, it should be drawn to exclude this sort of ad parody as the kind of thing that's permissible. Reverend Falwell, as a jury has found, suffered over $100,000 in damage from this, so this would certainly count. I think the fact that the allegation of incest is punishable by up to 10 years in jail in the Commonwealth of Virginia should be another factor that would go into a decision.
Well, there really wasn't, if you listen to the jury, an allegation of incest being found here. I mean, the jury said that this was not intended to be understood as an allegation of incest. No reasonable reader could understand it that way. How do you deal with the fact that if you say that if a victim or a subject of a political cartoon suffers emotional distress, he should be able to recover for that emotional distress? You say that on the one hand. On the other hand, you consider what some observer has said, that the whole object of political cartoons is to attack and to inflict distress. And I believe this one man named Long, who has written about it, said a political cartoon is as welcome as a bee sting when you're the subject of it. So do we destroy all political cartooning in the country if we allow emotional distress victims to recover for that?
No, Your Honor. This is a much more serious case. Normal cases of parody essentially start with some aspect of the character and then perhaps distort that somewhat. This is a distortion that's not based in any fact whatsoever, and even if a jury has decided that no one would believe this, should we then give the petitioner in this case a free pass simply because his allegations were so outrageous? I think instead what we should do is look to the fact that these are allegations. Simply, they were so over the top and so outrageous that no one would believe them. That doesn't mean then that we should hold the petitioner blameless.
Mr. Kessler, is it your position that this so-called interview was in fact nothing more than a gratuitous insult and not a genuine parody? Is that your position?
That's right, Your Honor. We, from the depositions involved and from basically the testimony of the petitioner, it seems that the only effort here was to assassinate the character of a respected public figure.
So then I would like, can you tell us how we might be able to guide the nation as to what is a gratuitous insult from what is a bona fide parody?
Well, this is a difficult standard to decide, and this is a difficult question before this court today. We would suggest that in cases which are as severe as this one is, where an allegation is alleged that is against the law in the Commonwealth of Virginia, perhaps where there's testimony by the defendant in the case that his only intention was to assassinate the character of the respondent, we would think that these would be the sort of factors that would go into a decision of this sort. And just because this is a difficult decision does not preclude the court from drawing the line somewhere. The First Amendment does not need to be the sort of thing where we cannot even begin to deal with these issues.
Mr. Kessler, we're not just here to decide this particular case, you understand. We wouldn't have taken the case if that's all that was at stake. We're here to give some guidance to the lower courts on how to apply the law to future cases where public figures claim they've been emotionally distressed by something that's been said or published about them. I've been listening very carefully, and I haven't yet heard from you any articulation of the standard that we should be applying. You're telling us we should apply one, and I may agree, but I'm looking to you as the advocate for the plaintiff here to give me some guidance as to just what those standards should be, and I haven't heard it yet. Can you help me?
Well, yes, Your Honor, we can try. This is the sort of case where our suggestion is that on the facts of it, this case would fit under that. So we could try to find a standard from that point. We could begin by the intent of the defendant in this case, which is so clear. And it would be rare to find another case where the intent of the defendant would be so clear that the efforts were only to inflict intentional distress. In cases of ad parody in the normal case, cartooning, lampooning of that sort, you're not going to find cases where the cartoonist so easily admitted to the bad intent and so easily and forthrightly said that assassination of character was the only thing. So we think that that would be a standard to start with, that the standard must be very high to prove empirically. And beyond that, we can start with questions such as alleging a blatantly illegal act where there's no kernel of truth.
Let me ask you a question, and following up my brother Carson's question to you. One of the things we are concerned with is the effect on speakers and publishers who are sitting there penning an article or a parody or planning a speech, and we don't want to chill them unnecessarily, certainly in a society when it's so important to have an interchange of ideas. How do they know what a jury is going to later determine is in their minds in terms of their intent to cause distress or not when they're sitting there writing this thing? What kind of a line can we draw that will let them feel safe that they can go make their cartoons and write their speeches and publish their articles without being afraid of huge damage suits at the end of the day?
Well, one beginning of it is that the jury routinely will decide what is in the minds of defendants. And in this case, simply because the petitioner is found against will not necessarily mean that all cartoonists for the rest of time will then put down their pens when rather they would have drawn a parody. This is a case that is like few others, and this is a case that is more serious than almost anything else that would come down the pike. Essentially, in this case, potential defendants and potential cartoonists would only worry about cases where it would be so blatant and practically the defendant himself would have to admit that the only intention was to assassinate the character. All that these potential defendants would have to do is keep their mouths shut.
Do you believe that in reversing the jury verdict below, that will only encourage those few publishers who act recklessly to make their publications and statements even more outrageous and more vicious and more vile in order to avoid a jury finding that there was any element of truth and that there was no falsity in those statements? And if so, isn't that simply rewarding a reckless publisher for having his publications go over the edge, if you will?
It very well might, Your Honor. Our concern is that if the jury had found that this was a believable assertion, then we wouldn't be worried about this finding and we wouldn't be in front of you today. But what ended up happening is that the jury found that this was so outrageous that no one would believe it. And I think then there is the concern that we would reward other magazines, other cartoonists, for claiming something that is incredibly outrageous and then saying, well, no one should have believed this, and it wouldn't be reasonable to believe it. That's not a finding that this court should feel comfortable with either.
Now, let me ask, following Mr. Justice Deichmann's question to you, let me ask whether or not, if the jury had found that a person out there could read this and believe it's true, that we would have an obligation to review that finding at this level?
Well, under Bose, there would be, since the finding would have been against the speaker in this case, then we would urge that there be a review of that. Although in this case, we think that there's no need to review that, since the question on appeal is the intentional infliction of emotional distress, which seems clear to us.
Do we have any obligation to review the jury's finding in favor of the speaker in this case, or the publisher?
Well, the jury did find in favor of the speaker on the libel count, and so we would be happy if this court were to review that jury finding in light of the libel count. But since that's not on appeal, we would not ask that in this case.
You may proceed.
Okay, thank you. This court has a tremendous responsibility to uphold the right of free speech. But the application of this right must be done in such a way that other rights are also respected. If we are to allow all claims of violations of the First Amendment to succeed simply because we are worried about implications of punishing speech, then we would inflict far greater damage on the rights of other people. The respondent in this case had a right not to suffer intentionally inflicted emotional distress due to false assertions not only about himself, but comparing his mother to a prostitute. This right must be protected as carefully as the First Amendment, and in this case, the right can be preserved without treading on free speech. The ad parody, which was intended to have Campari liqueur as its subject, used Reverend Falwell as its innocent victim. It would be entirely possible to find that intentional actions, which are as severe as this one, are not protected speech. Will newspapers be forced to edit out their most exciting news? No, they will not. Will plaintiffs routinely win cases under this tort when First Amendment rights are being exercised? No, they will not. A repetition of this case will not soon happen, and when they do, a jury will be happy to hold the perpetrator responsible, and a court should feel its duty to affirm the finding of intentional infliction of emotional distress. This case is no threat to the media. It will be the rare case indeed where this kind of behavior will ever be replicated, but where it occurs, it deserves the condemnation which the jury gave it, which the Fourth Circuit found, and which I respectfully submit this court should affirm.
Thank you, Mr. Keshup. The matter will stand submitted.
Well, this isn't like the Supreme Court, but let's give our advocates a hand. Rahul, I haven't seen you smile that big in quite a while now that this is over. I have to confess, I'm a little ambivalent about this session. I'm happy that Rahul and Elizabeth did so well, but I'm a little depressed that these students are already better lawyers than I am, and they haven't even gotten their JD yet. In the next session, you're going to hear from the named players in the case of Jerry Falwell versus Hustler Magazine and Larry Flynt. During that session, we are going to invite you in the audience to ask questions, to come down to the microphone here and to ask questions you have for either gentleman. However, we're going to reserve the last 20 minutes or so of the sessions exclusively for questions from the media. We thought you might enjoy seeing a press conference with these two incredibly influential Americans. I also call your attention to the fact that the Courts and Commerce bookstore is selling selected works by several of our participants. If you would like to purchase one, I think you might be able to prevail in getting its author to autograph it for you. On the handouts, you see we have a listing of the various works that are available. Also, I was asked to say this. We're going to take a 10-minute break now, and the person who is parked in Slaughter Lot with a maroon-purple Chevy plate that begins with ZJC may want to go see if their lights are on. You've got 10 minutes. Why don't we now take a 10-minute break, and then we'll come back for our next session. Thank you very much.
Tonight, we'll bring you a debate between Hustler magazine publisher Larry Flynt and the Reverend Jerry Falwell on the First Amendment rights issue brought up in this case. That's tonight here on C-SPAN at 8 p.m. Eastern.